Within the past year, FINRA has graciously indicated that it will open up its arbitration procedures to registered investment advisors. The question is, should our RIAs accept that invitation? Here to address that question is our next speaker, Jeff Hines, from the Goodell DeVries Leech Dann firm in Baltimore. Jeff's areas of practice include professional malpractice, toxic tort and environmental litigation, pharmaceutical litigation, product liability and commercial securities, and employee litigation. Jeff is currently defending broker-dealers in cases filed with FINRA, and he deals with FINRA's enforcement department and defends broker-dealers and registered representatives in Rule 8210 examinations and customer arbitrations. Please welcome Jeff. Also, let me note that Jeff most recently was selected as Lawyer of the Year in the field of legal malpractice in Baltimore. Please join me in welcoming Jeff Hines.
Well, that was a bit tepid. Look, I can't guarantee that this is going to be the best seminar you've ever attended. I can't guarantee that this is even going to be the best lecture that you're going to attend today. But I can guarantee that we can irritate the hell out of the people above us. You see, because they're sitting through a security seminar today, one floor above us, and they're wondering whether they made the right choice. Okay? So I want a big round of applause so they know they're in the wrong place. All right? Come on. Yeah! Yeah, there you go. There you go. So, FINRA, as you all know, over the last few years, has attempted to grab and start to control registered investment advisors. The vast majority of disputes between brokers and investors is resolved through FINRA's arbitration process. However, registered investment advisors don't have access to the FINRA for the most part. There's approximately 28,000 registered investment advisors in the United States. There's going to be more. We see more and more funds start to go to registered investment advisors. That's going to generate more claims, and they're going to have to be resolved. The difference, this is a chart that we can look at, and it touches on some of the differences between a registered investment advisor and a broker, but I want to focus on the last one, and the fourth on the bottom, which talks about the different standards of care. Registered investment advisor has fiduciary duty, has to put the interest of his clients above his own interest, whereas a broker is subject to fair dealings and suitability standards and the like. That can make a tremendous difference, that standard, when you're defending a case. I have a current case now in FINRA. If the conduct is to be judged by the breach of fiduciary duty standard, we probably lose. If the standard is to be judged on the suitability standard, we probably win. So the attempt of all the claimants when they come into FINRA is try to blur the line, trying to create a breach of fiduciary duty standard. It seems to be starting to be helped out by the industry. It makes a big difference. So recently, FINRA has promulgated this new policy where they're going to accept registered investment advisor claims and handle them through the FINRA arbitration process. So the question we have to ask as attorneys when faced with a claim and faced with what do we do with our client, is there a good reason to go before FINRA? Now, in order to have this choice, the registered investment advisor has to pay all the surcharge fees. The parties have to agree to it after the dispute arises. Now, because of that, I think this is something that lawyers should consider when representing registered investment advisors, because it allows us to look at that particular case and that particular set of circumstances and make the decision, hey, is FINRA a good idea? We know generally what's going to happen in FINRA. We're not sure what's going to happen in front of a jury. A lot of registered investment advisors use AAA arbiters, which they're very expensive, so I don't even know whether that's such a good deal. So that's what we're going to do. We're going to look at that and say, hey, how do we make an informed decision? Now, one of the problems that you may hear about this program is FINRA doesn't have the right to take any action to enforce the award. Let's say they rule against a registered investment advisor. They don't have any ability to enforce it. You would have to go to court. I don't really foresee that to be a problem. That's something that can be worked out among the parties. So let's talk about the pros and cons. At first, I have to make a disclaimer. I am not a big fan of mandatory arbitration clauses. I'm a lawyer. I like the legal process. I'm familiar with the legal process. The plaintiff's not familiar with the legal process. I like the ability to take depositions. I like the ability to have some young associate work really hard late in the night to draft a motion that I get to argue and look really good. I like that process. So I'm not a big fan of these RIA brokerage contracts that say, hey, we have to go through mandatory AAA arbitration. Not a fan of those. I think AAA arbitration is expensive. I think you do have lengthy discovery. The one advantage of it, and it's a significant advantage, is you can potentially make it confidential. So that, I don't want to rule that out, but as far as cost savings, I don't see it. FINRA is a little different. So these are the top 4 reasons why I think registered investment advisors may favor FINRA arbitrations. One, if you should get an arbiter who has some familiarity with the industry. They're faster, the cost is cheaper, and FINRA is industry friendly. Now this last one, number 4, I put a question mark by that because I'm sure many in the audience are like, what, are you crazy? It's not industry friendly. But if I had a group of investors in here, they'd feel completely different. They'd say, oh my God, it's you know, playing with the house dice. So maybe that means it's a good program because both people hate it. I don't know. But we'll talk about that. So the panel should be experienced with security claims. This is helpful. This is important. You don't have potentially a jury who's uninformed, who's just going to learn about it during that fake sort of session that you have with them. I mean, a trial is theater, nothing more and nothing less, and that's what you're giving them, that information, and you hope that they respond. You think you would get a little more play with somebody that has some experience with the industry. Now, there are different standards, and we talked about that RIA claims, or breach of fiduciary duty claims, most of the FINRA cases revolve around suitability, know your customer rules, churning and things like that and the like. And FINRA is not hiring arbitrators to specifically handle these type of claims. They're going to go with their ordinary panel. So does that present a problem? And I would argue that it doesn't. These are some statistics that were pulled off the FINRA website, and it just talks about the types of complaints that have been filed on a year-to-year basis. And as you can see, almost everybody that files a claim in front of FINRA throws in the breach of fiduciary duty standard. They throw it in because if they can get the panel to buy into it, it makes their ability to prevail the claimants easier. So they should be familiar with it. They should be able to handle that concept. And it's really not that difficult of one to grasp. I mean, you can explain to people what a fiduciary duty standard is, and for the most part, people get it. Now, FINRA is faster. Normal court case takes 23.4 months. In federal court, I don't know your individual state courts, but usually state courts are a little bit slower, at least in Maryland. This is data taken from FINRA statistics, and it talks about overall cases are resolved in 14 months. Simplified decisions are resolved in 7 months. Now, simplified decisions are where amounts in controversy are under $50,000. And you have one arbiter and you move pretty quickly. Hearing decisions that are more complicated and involving more dollars take longer. But it's faster. It's a faster proceeding. And it's cheaper. I don't know. I've handled some plaintiffs' cases out there, and I've handled many defense cases. And it is very difficult to try a case now of any consequence involving professionals for under $100,000 on either side. I mean, you get experts. The experts are, I mean, what do? You try to say, keep your bill down, I need to see everything. Well, you don't need to see everything. I need to see everything or I can't have an opinion. And they'll run you $20,000 for just their fees. And then if you want to look at the file and be prepared, that's going to cost you more. You have 4 depositions. You're going to have experts. I mean, it costs money. This can be an advantage and a disadvantage to what you want to do as a registered investment advisor and whether you want to involve yourself with FINRA decisions. Because it could well be that you say, hey, I want the expense. I want to grind this person into a pulp. I'm the big boy. I have more money. I want them to go away. I want to set up a bar so that plaintiff's lawyers won't take the case. I mean, if somebody came to me, I'm not a plaintiff's lawyer, but if someone came to me and I could not recover the potential recovery of, say, more than $500,000 I would not take the case on a contingency fee. It's just too risky. You're putting too much money in and too much expense. The client controls the decision process. You may have to try the case. So having an expense out there, forcing the claimant to go through this discovery process does act as a detriment, as a punitive measure really against investors and plaintiffs' lawyers who are going to chum for cases. FINRA's cheap, discovery's limited. You got canned requests, you have no depositions, you have limited motions practice. The trial's Wild West. I remember the first time I tried a FINRA case, couldn't believe it. It was $1 million of exposure. Went in this little tiny room in Washington, D.C. with one of those little tiny tape recorders, and you say, can you play back the tape? And I mean, so it's worthless. There's no transcript whatsoever. And you're like, my God, the industry set this up to solve $1 million claim, and this is what you're dealing with? I mean, I don't know. It must work. We keep doing it. But what you do in those kind of cases as a lawyer is you basically, it's kind of fun. I kind of like it because you go in there and you say, you take your deposition, you sort of ask questions to try to get the horse, in the barn. You try to ask questions and block them in. You don't have a deposition that you can rely on. Maybe you've gone to the internet, maybe you've gone to Zippo or Zappo or whatever it is and find out that they have 20 vacation properties in Florida, and then once you get them in, you cross them, okay, and that's fun, okay. And if you have an experienced FINRA lawyer that's used to doing that, that's comfortable thinking on their feet and trying cases, basically you need an old person to try the case because young people don't try cases anymore. I mean, I hate to say that, it costs too much money, and so no one does it anymore. Only old folks do it. I mean, I think they're going to be carting us out in wheelchairs when we're like 95 to try cases because they can't tell stories. They're terrified. You tell a young guy, get up and ask them questions. I mean, they wet their pants. I mean, serious. Because they're not allowed to make mistakes. There's not a vehicle for young people in this to go out and try the seat of their pants, auto tort case. People don't do it. They settle those. And so you have people that sit in back rooms taking depositions and are terrified to be in a court. Plaintiffs' lawyers too. So there is an advantage to go into FINRA, and there is an advantage to going with an experienced lawyer who can think on their feet and probably out-lawyer the other person. So there's an advantage to that. Now, is it industry friendly? And let's look at this. I'm going to look at number 2, which is 78% of FINRA cases resulted in some recovery for the investor. Now, what does that mean? And when you look at that, this is data that's taken off the FINRA website, that seems to suggest that this is bad for the industry because most of the time the investors win. But what the data doesn't show is how much do they win, how much do they get? And there are other people that rail the other way. I mean, this is an article by a judge who co-authored some study and found out that in 14,000 cases, the claimant got less than 12% of the amount claimed. Now, that looks really bad for the investor, very favorable for the industry. I don't know. I mean, we don't have enough data on it. I think there are circumstances where you're not going to get a runaway decision by FINRA. I know it's changing a little bit now with the public arbiters. I know John Warden's going to talk about that at lunch. There's circumstances where they've allowed punitive damages. So this is somewhat fluid, but it goes both sides of the equation. Now, we have this talk about public arbiters. I mean, where's my guy? Where's my guy? Where's my guy in the industry? I mean, that's the whole thing. This is set up here, so I get somebody to help me out in there. Somebody that's been behind the lines, and somebody that's been to the war is going to know what the hell I'm going with. That you can tell a guy a bunch of stuff, he could still be an idiot. I mean, you're not idiot-proof. So FINRA's now gotten rid of your guy. You can have the claimant can choose 3 public arbiters. And so there's going to be some talk in one of the later lectures, I think, by the gentleman in the front row here, and he's going to talk about public arbiters and what the significance that has been. And we both use this same chart. It's in your materials. And you can see in 2012, when it was a public arbiter, about 50% of the times the claimant won. When it was a non-public arbiter, or at least one non-public arbiter, they only won 33% of the cases. Now, this is limited data. you know, what's it? Just there's lies, damn lies, and then statistics. You know, so this is similar to that. In 2013, it looks like it's evened up a little bit, but I think in general, you know, if an industry would rather have at least one industry-related arbiter on the panel. So the top 6 reasons why we might disfavor FINRA arbitration. You might have an experienced federal judge that's going to kick out a lot of the cases. Motions practice. Motions practice is great at winnowing down the types of claims. If you're in federal court, if you're in state court, I don't think that's so true. Same thing with more extensive discovery. The additional length of the litigation, we touched on that. That oftentimes benefits the registered investment advisor because you set up a wall for somebody who's going to sue you. You basically block them, and you don't have to worry about these small claims because nobody's going to bring them. You have no right of appeal in a FINRA case, and that's, although we're going to talk about that, there's some people, they're going to talk later about that, but maybe that's not so true, but in general, you have no right of appeal from a really bad FINRA decision. That's a big deal. I mean, that's a big deal. For the most part, I find in state courts, if there's a really bad decision that's resulted in big money, you're going to get a fair review. I mean, you're at least going to get a review of it. You may not win, but you're going to get somebody to look at it and say, is this right? Is this fair? I hope so, because I have a $60 million case going to trial September 30th, and I'm praying to God, if we lose, the appellate court's going to help me out. I would not want to arbitrate that case. And then the rules of evidence don't apply really in an arbitration case. And, you know, generally the registered investment advisor is able to hire a more experienced attorney. They're able to put more money in the case, and they're able to apply the rules of evidence. So that weighs on the side of not doing FINRA arbitration. But it's there, and I think it's something that we as attorneys have to consider. We have to consider everything, and both the benefits and the costs of doing it, because since it has to be agreed to, you have to sit down with a lawyer on the other side who's experienced, who's going to be familiar with FINRA arbitration, and convince them that in this particular case, this is good for both sides, and we're both going to go forward. We're going to try to do it in a fast manner. We're going to try to do it in a cheap manner, and maybe this is advantageous. Maybe you want to keep the customer, and maybe this is a dispute that you want resolved in some even-handed manner because you want the person to keep investing with you. I mean, I've seen circumstances where people have sued, and at the same time, they still have their money with the investor. I mean, so there are other opportunities out there. So I would look at, certainly depends upon the dispute. Does speed and cheapness matter? If it does, that's something that we got to consider. Is confidentiality important? I mean, if confidentiality is important, then the mandatory arbitration clauses with the AAA, guaranteed confidentiality, I mean, that's the way to go if they'll remain enforceable. How strong will your pretrial motions be? I mean, will you actually, I mean, it's nice to say, oh, we're going to have motions practice, and a lot of times that's just a way for lawyers to generate a lot of fees. I mean, you should be able to tell whether any motion you file is going to be successful or not. I mean, sometimes filing a motion is not worth it. You can educate the judge in other ways. Maybe the motions judge is not going to be your trial judge, so why are you spending money educating the person that's not going to be at your case? So you need to make these decisions. And is the amount of controversy small? I mean, are you the type of registered investment advisor who wants to give somebody an opportunity to resolve their claim that may not otherwise be able to get a lawyer? If it's under $50,000, maybe you do it quickly. I mean, I don't know. But you have to sit down with your client, because that's what we're in the business of doing, is serving our client and saying, these are all the issues that we got to consider. This is my experience. What do you want to do? And it's a choice. Now, when they announce this, the SEC said specifically that this was not our attempt to try to take over the business, to take over the compliance of registered investment advisors. They said, we are doing this because investors and registered investment advisors are clamoring for this. Clamoring for this is what they said. The Wall Street Journal in May of this year said 4 people have chosen this procedure. Okay, so I don't know where the clamor is coming from, but it hasn't happened yet. But it is in your quiver. It is something to consider. Thank you very much for your time. I appreciate it. Thank you very much.